Hi everyone, welcome back to the Thinking Crypto channel. I have a special guest with me today, Joseph Hall, who is a partner at the law firm Davis Polk and former managing executive for policy at the SEC. Joe, it's great to have you.
Thanks.
Joe, I'm excited to speak to you because you recently penned an article about the Ripple SEC lawsuit situation. But before we get into that, I think folks would love to understand more or get to know you better. We could start with your background. Where are you from? Where did you grow up?
I grew up in North Carolina mostly. Went to high school and college in North Carolina, and as a child, I lived in Tehran for a few years. So was exposed to kind of the rest of the world at a very early age, and my family traveled a lot.
Wow. That's very interesting that you were in Tehran at a young age.
Before the revolution. So.
Wow. That's very interesting. How did you end up working at Davis Polk and becoming a lawyer and getting into the legal industry?
So after law school, I clerked for a federal judge for a year. And then after I clerked for the federal judge, Davis Polk was the first firm that I started working at. And so I've been at Davis Polk. I started at Davis Polk about 32 years ago and have left for government service once and left for an in-house position at once. But it's the only law firm I've ever been at.
Got it. And then at your tenure at Davis Polk, you left to go work at the SEC. Can you tell us about your time there and what did you help accomplish at your tenure at the SEC?
Sure. I was working for Bill Donaldson, Chairman Bill Donaldson, who came in. This is sort of ancient history at this point, but who came in about a year after the financial or the IPO. The dot-com boom and bust, and then the Enron and WorldCom scandals, and then the scandals around the mutual fund late trading. So I was there at a very busy time for the agency, and as I was his chief of staff, the title was managing executive for policy, but it was effectively chief of staff. So my real job was more management. It was more, trying to help Chairman Donaldson get his policy agenda through the commission. Man, it was great for me because I had been sort of a deal lawyer all my life before that, and having that position at the SEC gave me kind of a 360-degree view of what the SEC does. The various statutes that it administers and the various interest groups at play, and a much more sort of rounder view of the U.S. securities laws than my narrow focus as a deal lawyer.
Sure, and that's where I was so excited to speak to you because you have that holistic view. You've been in-house at the SEC while also in the legal industry, and I think your perspective is going to be, well, as you articulated in your article about Ripple, well put. And what made you decide to write the article recently?
Well, I think a couple of things. One, there's going to be a change in leadership at the SEC, and that's always sort of a time to look at the SEC's agenda and sort of make some predictions or identify some areas where I think it would be useful for the agency to go. And I do think it's time, as I said in the article, I do think it's time for a fresh approach to crypto issues. So those are some thoughts I've been having for a while. But then, the day before Chairman Clayton stepped down, they filed the suit against XRP, which, I found pretty astonishing. Again, not because I don't see the issue and not because I don't sort of understand the legal theory behind the case, but there's just a lot of things about the timing and about the decision to take action against Ripple Labs, and about, frankly, some of the statements that the commission is making in that complaint that were frankly quite surprising to me. So the two things together just sort of naturally coalesced, and I had some time over the holiday, so I sat down and wrote about it.
So Jay Clayton's move, in my opinion, it seemed like a very crass move, and the timing was weird, as you alluded to. What do you think was the motive behind that? Was it Jay Clayton himself? Maybe there's like a personal thing between him and the folks at Ripple. It's a political thing, or this is a, hey, you're disrupting the status quo. This is to push you back a bit or set you back a bit.
Yeah, those are not at all sort of motives that I would attribute to Jay Clayton or to the commission at all. And I don't think it was a crass move. I also don't think it was sort of the empire striking back. I think it reflects some strongly held convictions at the commission, which are, frankly, they are grounded in the law about what is a security and what do issuers and promoters of securities need to do. And so it's at some level, it was, it came out of a very natural progression of the way the commission looks at the securities markets from the point of view of how the securities markets have worked over the last, several decades, and certainly from the point of view of the way that the securities laws were designed. And my point of the article is that I think it's time to move on from this question of, is it a security or not? Because right now, the way the way the analysis works is it a security? And if the answer to that is yes, then sort of the entire weight of the federal securities laws and all the implications of that now apply to it. And my thought is that, maybe that does not have to be the approach. Maybe we could still sort of acknowledge that under the Howie test or under sort of traditional methods of analyzing, whether a particular instrument is security, maybe that shouldn't be the end of the analysis. Maybe that should just be the beginning of the analysis. And once we have decided that, or once we've concluded that something is a security, then the question is not necessarily, let's regulate it out of existence, which I'm afraid sort of is what kind of happens with crypto right now. I think the question should be, okay, it is a security, but it's not like what we think of traditionally as a security.
Right.
It's not like a stock or a bond. It's not used for the same purpose necessarily. And that's the funny thing when you talk about crypto. There's obviously endless flavors of crypto, and there could be some that are very much like a traditional traditional security asset, but there's others that just aren't. And so I think the question is, what are the fundamental concerns under the securities laws, and how do we address those with this new asset class without imposing, sort of other aspects of the securities laws that end up making the asset worthless or not being able to be used for its intended purpose. So that can be done by the SEC. Mm-hmm. And if I had one criticism of the Clayton approach, it's that they didn't take that second step. I mean, I think that it was important, I think, for the Clayton SEC to come out in 2017 and say, there's a lot of bad stuff going on out there.
Sure.
Or out here. There's a lot of capital raising for speculative business purposes that's going on that needs to be regulated, like capital raising for speculative business purposes. My criticism would be that they didn't take the next step and say, okay, now that we have sort of put the world on notice that certain kinds of crypto may well be securities, they didn't take the next step and say, okay, how does it make sense to regulate them now that we're labeling them securities? And the staff of the commission has actually given lots of thought to that question. And I saw this I saw this a number of different times in my interactions with the staff. They actually do have ideas about how to handle this, and they weren't necessarily given the freedom that they needed to begin to develop those ideas and refine those ideas. And the commission does have the ability to do that. The commission does have the ability through notice and comment rulemaking to craft a new regulatory regime that is appropriate to this asset. Now, it would be nice, frankly, if Congress would come in and set the ground rules. It really should be Congress that's doing that, but we've seen over the last many years that it's very difficult for Congress to sort of focus on major pieces of legislation, and particularly in areas like this that nobody who's setting the laws really has a deep understanding of it and a deep familiarity with the issues. But again, I don't think it's a partisan issue. I don't think this is a Democrat versus Republican issue. I think it's a problem. We have a huge asset class that at this point nobody knows how to regulate, and the regulators are not getting clear direction from Congress on how to do it. And so it then ends up being, the regulators trying to do things piecemeal, and without a lot of sort of guidance from above. So it's an issue, and the asset class is far too big right now to be left to that kind of nebulous state of regulation.
Sure. In your article, you alluded to potentially there was maybe a divide among the commissioners at the SEC. We've seen Hester Pierce in particular. She's known as Crypto Mom. She's very pro crypto. She's put out a lot of different legislative ideas and wrote op-eds and so forth in favor of proper regulations. So potentially there was a divide among the commissioners, and when Jay Clayton was on his way out, he kind of just, well, here it is, and you guys handle it from now on. Do you think that's what kind of happened?
Well, we don't know, because when the SEC takes a regulatory action, when they pass a rule, if one of the commissioners dissented, it's very common for them to write a dissent and explain what their position was. And Commissioner Parrish has done that on a number of occasions. They follow a different practice in litigation. I think there is an understanding that if the commission is going to file a lawsuit, that you just can't have the various commissioners going out and criticizing that lawsuit. So we don't know at the end of the day whether Commissioner Peirce and Commissioner Roisman, just in particular, I call them that in particular. We don't know whether they signed on to the lawsuit. It was just, the timing just seemed to be odd to me. It's a very major step that the commission took. They made it on Jay Clayton's last full day in office, and the co-directors of the Division of Enforcement both left soon thereafter. The director of the Division of Corporation Finance, Bill Hinman, had left a few weeks earlier. So to be making such a momentous step like that, just looks to me that they felt that they were running out of time. And it takes, the commission acts by majority vote. So they needed to have at least 3 commissioners vote to authorize the suit. And if there were only 3 and not 4 or 5, then that was really the last day that the suit could be authorized. So, I'm speculating. I have no inside information, but just the timing of it just made me think, maybe everybody at the top of the commission was not on board with this. That will come out at some point. It'll become known at some point, but it may be a while before we really know what the true politics were there. So I'm just speculating.
Sure. And we know Gary Gunzler, nominated to be the chairman, appears he's going to be on his way in. Given his knowledge of cryptocurrencies, I've seen videos of him teaching about crypto and Bitcoin and blockchain. You talk about Ripple and XRP at MIT. Do you think he's going to come in, and once again, we're speculating here, and with his knowledge, maybe help bring some clarity here or put things in line?
I hope so. Okay. I think whoever was going to be President Biden's nominee to lead the SEC, I think was going to have to confront this issue. And I think it may well be the case that Jay Clayton didn't have to confront it, because when Jay Clayton came in 2017, 4 or 5 years in the crypto space, as you know, is an eternity.
Yeah.
I don't know what the market cap of crypto and Ether was in 2017, but I'm sure it had nothing comparable to what it is today. And there was also, as I said, there was a lot of bad activity that was going on in the 2016, 2017, 2018 timeframe.
Absolutely.
There was a lot of crap that went on. There were a lot of assets that were launched that were just kind of, just kind of a joke. They just seemed much more interested in getting money out of people's pockets than they were solving a real issue. And one of my very good clients, we were down talking to the SEC about crypto, and he's somebody who's very prominent in the space. And, I think his inbox was anytime somebody was doing an ICO, his inbox was going to receive a copy of the white paper. And he made a comment to the staff that, in 90% of these cases, he doesn't see what problem the token is solving. Right. In fact, if anything, the token seems to be adding more friction than it seems to be, solving a problem. And I think that was very true about that activity that went on in the middle of the, sort of in the middle of the decade. And therefore it's natural that the SEC's approach would be more of an enforcement forward approach. But I think we're past that now, right. And things have shaken out, and there are legitimate businesses that need to be able to operate, need to be able to attract capital, and they can only do that with regulatory certainty. So I think whoever was going to be appointed by President Biden to fill this role was going to have to deal with it maybe in a way that Chairman Clayton didn't have to. Now, when you then sort of just tee it up that way, I think it's much better to have somebody who understands the asset and understands the space, right. Being that regulator. And Gunzler was a very proactive regulator at the CFTC. That was historically an agency that took a much lighter touch to regulation than the SEC did. That's probably just my bias as a securities lawyer. But Gunzler sort of turned that around and was quite active in implementing the Dodd-Frank rules and dealing with security-based swaps and the whole swaps and derivatives market and everything. So he's clearly activist is the wrong word, but he's clearly somebody who's not afraid to tackle big problems. So you have the combination of somebody who knows the space deeply and is not afraid to tackle problems. So I'm hoping that means that he will approach this not from a regulatory perspective and sort of what's the right kind of regulation for this space, as opposed to just the what's derogatorily referred to as the regulate by enforcement approach. And so I think the signs are good that we've got somebody who can do that and who knows how to do that. But it's going to be a heavy lift.
Sure.
If he does decide to make this one of the centerpieces of his tenure, my prediction is that it gobbles up a hell of a lot of his time.
Sure, and this asset class is on the rise. We're seeing a lot of companies are setting up shop. A lot of big players, traditional financial players, are getting into the market. So I do want to ask, do you personally own cryptocurrencies? Are you a holder of XRP? If you can,
I don't. Okay. I've never owned cryptocurrencies. I'm a securities lawyer and I don't own securities. I invest in Vanguard and Fidelity mutual funds, and that's been the way I've been since I was a very young lawyer. It's just when you're a securities lawyer and you're constantly dealing with different companies and different products, you can find yourself very quickly not being allowed to trade them because of the conflict, or because you might have inside information or something like that. So
sure.
I'm a very plain vanilla investor. Now, I wish I had bought crypto. But no, I don't invest in the space that I practice in.
Sure. And I respect that. It totally makes sense. So you penned the article. So in your mind, and I know I'm asking maybe a moot point here because you kind of let your thoughts be known. Do you see XRP as a security, and what do you see the outcome being potentially moving forward?
Well, when you examine it against the Howie test, one can make arguments on each prong of the Howie test as to why it is a security. That's frankly one of the problems of the Howie test. It's just too elastic. And when the staff came out with their the SEC staff came out with their framework for analyzing assets under Howie, the framework just included multiple questions, maybe 30, 35, 40 questions, and came along with the standard disclaimers that no one factor is dispositive. And that's the issue with a judge-made test like this is you can argue all these points. So I see the argument as to why it's a security. Now I'll tell you, I have argued the opposite to the SEC in terms of XRP on behalf of clients who have been doing things with it going back several years now. So again, to me, that's not the interesting question. To me, the interesting question is, okay, let's say it's an investment contract under the Howie test, but that shouldn't be the end of that shouldn't be the end of it. It should be, okay, I'll give it to you. It's an investment contract. Now let's talk about the smart way to regulate it as a security. There might be some elements. There are some elements of the way we approach securities regulation in this country that could well be appropriate, including SEC review of an offering document of some sort. Probably not using the standard protocol of questions or standard protocol of topics that the issuer of a share of common stock needs to disclose. But there are things that probably would be useful for a purchaser of a crypto asset to know. For example, how much of the asset do the promoters control? Something like that. There are things that may well be relevant. And so I don't have a problem with that. But then the second step of then saying that all transactions in that asset have to be routed through regulated intermediaries, whether that's regulated broker dealers or clearinghouses such as DTC. That's where I then come in and say, okay, maybe those aspects of the regulation of securities are just not appropriate for this kind of asset. And that's the question. Again, that's the question that I know the staff has thought about, and that's also the kind of question that the SEC does have the tools to address if they're prepared to go through the arduous process of notice and comment rulemaking. That involves the SEC sort of proposing a regulatory framework for the asset class and then getting comments on it. Putting it out for public debate, and then on the basis of that public debate, the SEC should, in my view, what the SEC should do is come out and propose a regulatory framework for crypto. Now, Commissioner Peirce has, she's made she's come up with an idea, which is a very interesting idea of basically giving promoters of the asset sort of 3 years to make it appropriately decentralized. That's something that would be quite useful. I would actually go further than that, though, and not necessarily require. I don't think decentralization itself needs to be the watchword on this, because I think that I don't know why we force blockchain technology and tokens that are used on a particular network to necessarily be decentralized. Today you have to do it that way because that's the only way to get it not to be a security. But I think one could just as easily take the approach that, okay, it is a security. Let's stop arguing that question. Let's stop drawing analogies to oranges and whiskey warehouse receipts and Manhattan condos. Let's just cut it out with those analogies and just say, okay, it is a security. What's the best way to regulate this security so that we can get the benefit of the technologies that are going to employ this asset? We can encourage innovation in this field, and yet we'll still be able to address the consumer protection or investor protection concerns that are at the heart of the U.S. federal securities laws. Now, this will not be easy. As I said earlier, Congress ideally, frankly, should be holding hearings and should be making these decisions and should be drawing lines and coming up with ideas about how to regulate it and giving the regulatory agencies very clear directions on what Congress, believes that the policy should be. But you tell me, I don't see that happening anytime soon, unfortunately. It is unfortunate. But the SEC does have the tools to do it if they're willing to use them. And we can't discount the fortitude that it will take a commission to address these issues, to bite off an issue like this and to really see it through. It literally could consume major parts of any chairman's tenure. So I think that's to me a huge question as to whether there's a lot of issues that Mr. Gunzler is going to need to face on day one. That's always the case with the chairman of the SEC. There's always a long list of things that need to be done, and so prioritization is a huge part of his role, any chairman's role, and the question is going to be, where in that list of priorities is crypto? Sure. And again, with Chairman Clayton, I can understand why crypto was not at the top of that list, just because of the nature of the industry, 4 years ago. I think that has changed now.
Absolutely. The industry has matured, and you mentioned that there was a lot of scams, and I remember seeing a lot of it myself back in 2017, and a lot of hype around that. But I think there has been some maturity, and there's some quality projects in the market, and it seems the determination that will be made around Ripple and XRP is going to affect the rest of the market for sure. So I'm hoping Gary makes it a top priority.
It could. I mean, this is why this is another reason why I was so surprised that the lawsuit was filed, because the SEC just hasn't brought that many litigated cases. Telegram was obviously pretty huge, and Kick was pretty huge. But in both of those cases, I think the SEC's position and the SEC's chances of prevailing in both of those cases, I think, were much higher than they are in this case. And the SEC could have, rather than bringing a case against XRP at this time, the SEC could have continued to proceed with the easier cases, the cases that are, this more clearly a security under the Howie test. And they could have developed a track record and gotten some appellate court decisions, because of course, both Kick and Telegram never made it to the appellate level. So there are just a couple of district court decisions. They're, persuasive, but they're not binding on too many other courts. They could have chosen the SEC could have chosen a path of trying to develop case law in their favor, in a lot more cases before taking on something like XRP, because when the SEC gets into federal court, it happens all the time that they go into federal court with cases that I, as a securities lawyer, think should be a slam dunk, that the SEC's position is clearly right, and yet they don't prevail in federal court because they are going from a world where we all understand what the securities laws are trying to do, and we understand what the conduct is, and we see how the law applies to the conduct. But when you're in front of a judge, an Article III judge, who one day is hearing one day is hearing a criminal case involving cocaine smuggling, the next day is hearing a breach of contract case, the next day is hearing an EEOC case, you're getting in front of a generalist who may have no background in any of this at all.
Sure.
And the facts end up mattering a lot in situations like this. And so the facts here are, we had an asset that was, in the $30 billion market cap range, that was, the brainchild of a unicorn, in a Silicon Valley unicorn. And I think the facts of this are going to be
the judges, what the judge is going to see, is a case that doesn't seem to have been involving any imminent investor harm. The Telegram case, of course, was brought as an injunction right before they distributed the grams. So you can sort of see that, unless we act right now, investor harm is going to happen. The judge just might say, why, if XRP was a problem, you've known about XRP since 2012.
Right.
Why now? Well, what is going on here? So I think we start out with the XRP case, with a factual posture that may not be the best for the SEC. And I think that there's a good chance. I can't give you a percentage on that. I think there's a good chance that the SEC loses this one. And if they lose it, whether that's at the district court or, frankly, if they lose it at the district court, and they don't settle it, they'll surely appeal it to the Second Circuit. They could end up with a ruling that makes it very difficult for them to exercise any authority at all over the entire crypto space. And I don't think that would be a great thing, because I think, as I said earlier, I think there are some interests that the U.S. federal securities laws are designed to protect that would make sense here. It's just, you just have to be, very thoughtful about what kinds of requirements you put on this industry.
So let's say, to your point, they potentially lose this case, but would it then force them to put together a Howie test 2.0 or one that's specific to crypto and digital assets? Okay, we can't use the 80-year-old Howie test. It doesn't align. Maybe there's a second version.
So it's just in the nature of things, courts and agencies, move very incrementally. They move, and I'm assuming that a world where Congress doesn't step in and act. For now, we've got securities laws that were written in the 1930s that have a list of things that are securities that runs, several lines long. And one of those things is investment contract. And the Supreme Court gave meaning to that term in 1946. And courts have continued to give meaning to that term over the years. The SEC has an interpretation of that term grounded very clearly in what the courts have said over the years. In my view, there's some cases where I think they push the definition further than the courts do, but that's what people do. That's what lawyers do. Lawyers, are always, are always interpreting things in ways that achieve a result that they want to achieve. That's just normal. If a court comes out, whether the district court or the appellate court, so whether the judge sitting in the Southern District of New York or the judge on appeal at the Second Circuit, they're not going to come out and say, we don't like the Howie test for digital assets, we're going to create our own test. That's just not the way our system works. What the courts will do is they will interpret the Howie test. I mean, if the SEC does lose this case, they will interpret the Howie test in a way that gives more weight to the arguments that favor XRP not being a security than XRP being a security. And that is possible because as I said earlier, the Howie test is ultimately, very elastic. And I can argue this side of it or I can argue that side of it. I can make arguments both ways. The court is ultimately going to have to decide which side it comes down on. And that was my point about the proposition that XRP brings to the table here. XRP is not like the Munchie token, which is one of the first SEC enforcement actions where you just read the facts, you're like, this is kind of silly.
Yeah.
XRP is a legitimate business, Ripple Labs operates a legitimate business solving a real problem. And XRP is actually integral to solving that real problem. Right. And it's a huge market. And, it's just, there's just something that when you bring that in front of a generalist judge and they're going to say, wait a minute, and the SEC's complaint kind of ignores this. The SEC's complaint just sort of says they should have had disclosure and this should have been registered, and they deprived investors of this registration. The SEC's complaint does not go the next step and say, wait a minute, what if this was a security? What if they had registered it and provided all this disclosure? What happens next? And the answer is, what happens next is you suddenly got an asset that just can't be traded, on a peer-to-peer basis on a blockchain, because we don't have any rules for that yet.
Sure.
So I obviously haven't seen what Ripple Labs is going to say in response to the SEC's case, but I would expect that one of the things that they'll point out is, look, it's not just so easy to say they should have registered this, because once you do register it, once you start going down that route, suddenly you can't use the asset anymore. And that's missing from the SEC's complaint. And I think when they get in front of the judge is then going to look at this and say, I have no idea how the judge is going. If I were the judge, I would look at it and say, okay, SEC, I hear your arguments, but what are the consequences of finding that this thing is a security? I find it's a security, and I have to shut down this, very substantial, very credible, good company, or what kind of policy sense does that make? So because of that, the SEC could have, if they had, rolled enough in time, they could have brought, a number of different cases and more firmly gotten judges to sign off on their particular approach to the Howie test before going after XRP, and they didn't. And it's going to be very interesting to see how that plays out. I would have been happy with a settlement in the XRP case that sort of picked up on a concept that Bill Hinman talked about back in 2017 or 2018. The idea that an asset can morph from being a security to a non-security. I would have been happy with a settlement. And I still can. I think Gunzler's arrival at the SEC will obviously present an opportunity for a settlement. I would be happy with a settlement that, where XRP on the one hand sort of, it's always no deny. I'd be happy with a settlement where the SEC asserts that XRP was a security back in 2012, and some of those, some of those are early sales, but then just leaves open the question of whether it currently is today, and just let Ripple Labs sort of live to fight another day, not get into the question of whether it's a security today. And that was my, of the number of things that surprised me about the case. That was probably the most surprising, frankly. And I even know the paragraph number. It's paragraph number 8, right at the, on basically the first page of the complaint, asserts that XRP is a security today. It's one thing to say XRP was a security 5 years ago and they should have registered it.
Sure.
But I frankly thought it was too bad that the SEC asserted that it is one today, because to me, that's just saying, there's no, in the SEC's view, we've got to shut this company down. If they had left it at it was a security several years ago, and we're just not going to even touch whether it's one today, then to me that would have been an easier argument to make in front of the court. So whatever you think about the status of XRP today, it was clearly a security back then. They should not have sold it without registering it, or putting the kinds of restrictions that one needs to have for a private placement of securities. But the fact that they went ahead and they went there and they said it's a security today, I think is a warning sign, unless they take the approach that that I would advocate for, which is to say, quit asking that question. Just quit bothering me with that question. Let's just say it's a security. Let's just both agree that it's a security, and then let's ask, what's the smart way to regulate this thing?
Right.
If it's a security.
So to your point, let's say the outcome is it is a security, but given that it's a utility token to be used by banks and different payment companies and so forth, there's a leeway there that, okay, the banks can go without needing certain bells and whistles and all this stuff. To make it easier.
Yeah, and that concept, that term utility token is not a term that's recognized in our law, but that is a term that if the SEC were to embark on a regulatory project they could make distinctions between different types of security or between different types of crypto. You could clearly say, this is a payment token, this is a utility token, and this is some other form of token, and they could all be regulated differently. And, I believe that's sort of similar to the approach that you're going to find in Switzerland and Singapore and other jurisdictions where they, where they've looked at it. And I think you would regulate you would regulate a token that is meant to be used for payments, but that ends up being a security under the investment contract test, differently from the way that you would regulate a security or a security that's a piece of crypto that's a utility token that ends up being an investment contract under the Howie test. Now, I should step back and say I'm not at all saying that all crypto are investment contract. I'm not saying that at all. I think there are plenty of kinds of crypto that clearly are not securities. Bitcoin is the obvious example. I think there are stable coins, well-designed stable coins that are just not securities under the federal securities laws. And those should stay outside of the federal securities laws. What I'm arguing for is an approach where, where two lawyers sort of acting in good faith, can sort of say, look, we can both make reasonable arguments over whether or not this thing is an investment contract. That's where I'm saying we need a new approach, because now the stakes are too high. I can argue it's not an investment contract. The SEC attorney can argue it is, and the stakes are enormous, because depending on which one of us wins, it's either unregulated or it's regulated to death. And that doesn't make sense.
Right.
It shouldn't be that binary choice between being regulated to death and unregulated. So let's, on these close cases, let's stop having that argument. Let's quit putting our resources, again, into making, metaphors and analogies to oranges and whiskey warehouse receipts and Manhattan condos. Let's stop that. It's not productive. Let's say, okay, it falls under the banner. Let's figure out the best way let's figure out what the best consequences are for that. And I don't think the best consequences for that are to apply the full panoply of federal securities regulation to it, because it just won't work. The securities laws were not designed with these things in mind. And so, you're trying to get a round peg into a square hole. It just doesn't work. You need a new approach. And that's what I would hope, Mr. Gunzler will take the time to do. And again, there's a lot of different things on his plate. And it would require prioritization. And as I said, it would suck up a lot of his energy and effort at the commission. And I did see that with Bill Donaldson. Bill Donaldson, the guy, the chairman that I worked for, had founded Donaldson, Lufkin, and Jenrette, which was sort of the leading independent investment bank and broker dealer. He had been the chairman of the New York Stock Exchange. He had been the founding dean of the Yale School of Management. I mean, he'd been a soldier, or officer in the Korean War. This was a guy, who came to the commission with an enormous amount of credibility, like Mr. Gunzler has. And he tried to tackle the big problems, and he did. He did tackle some really big problems, problems that had been out there festering for years, if not decades, about market structure issues, the regulation of hedge funds. Yeah. And you can't imagine what a slog it is, because for everything that you want to do, there's always an industry on either side of the issue, and then it gets into Congress. And I just, one thing that I loved about Bill Donaldson is we were dealing with an extremely contentious issue that involved, seems quaint to talk about it now, that was called the trade through rule that had to do with how securities exchanges are regulated. And there was the so-called New York Stock Exchange model with, back then, 15 years ago, it was a lot of floor brokers, and there was the NASDAQ market, right, that was, all electronic. And and it was just sort of the clash of the titans between these two business models. And Congress got involved in it because everybody had their lobbyists talking to Congress. And so I walked into Donaldson's office one day, and he was just hanging up the phone, and he had this sort of bemused smile on his face. And he had just been called by the chairman of the Senate Banking Committee, who had read him the Riot Act, to try to tell him not to do what was pretty clear that the SEC was about to do. And it just didn't faze Donaldson one bit. You know, he could have the chairman of the Senate Banking Committee call him up and scream at him. And Donaldson just says, yeah, thank you for your views. I'll take them into consideration. It didn't faze him one bit. And I think Gunzler, has that kind of credibility. And I think he's got that kind of intelligence. And I think he will do the right thing. I think the biggest question that I would have is, if he takes this on, as I said, I've said this 2 or 3 times now, it's going to consume a lot of his tenure as chairman of the commission.
So Joe, let's say Gary gets in there, he gives you a call and say, Joe, come work for me, help me out here. Would you head back to the SEC?
I say, been there, done that.
Well, we need someone like you.
I would love to go back to work on the staff at some point, but I'm 57 years old. I don't have that much longer as a practicing lawyer. I will retire at some point in the next few years, but I don't think I'll be going there now. I hope I have some role, in my, in whatever they do, by representing my clients' interests, and commenting on their proposals. And, I know all the folks at the SEC who deal with this. I'm in regular contact with them. They are a wonderful group of people, frankly, the staff members who work on crypto. So I hope I'm part of the dialogue, but it'll be from the outside and not from the inside.
That's a bummer. I hope you change your mind. So I do have to ask, in 2015, the Ripple settled with I believe it was the FinCEN, and FinCEN categorized them as a virtual, XRP as a virtual currency. Do you think that helps Ripple in this case, given that, once again, the SEC was nowhere to be seen?
No, not really. That's the way, the way we regulate the financial markets in the United States is we divide up regulation among a lot of different regulators, and each regulator has its own mission and its own set of concerns, its own set of priorities. That's not the way other countries do it. There are other countries where you have a unified financial services regulator, but in the U.S., in the financial service, in the regulation of financial services, we divide it up, and I think that's a good idea, frankly. It creates there are good things that come out of regulatory competition. There are good things that come out of having different regulators having different agendas and different priorities, because it can make sure that important concerns are not overlooked, and you don't have a single agency subordinating one set of concerns to another set of concerns. So I think the way we do it in the United States, you might call it a federalized system of financial regulations, actually makes a lot of sense. But FinCEN's issues are not the SEC's issues. FinCEN's issues are financial assets being used to commit crimes, or financial assets being used to fund bad activities. Those are FinCEN's concerns. And so, FinCEN has categorized digital assets. FinCEN does categorize digital assets based on what they mean in terms of the priorities that FinCEN has. Completely different priorities at the SEC. Not completely different, but quite different. The SEC's concern is the protection of investors and the health of the market, sort of the two things. They want robust, fair, honest trading markets in financial assets, and they want to make sure that investors' interests are protected. Now, there's clearly an overlap between FinCEN's concerns and the SEC's concerns, but they're not the same. So, if you went to the CFTC, they would say it's a commodity, and because they treat FX as commodities. There's again, who's the right person to solve these things? Congress. Congress could easily come in and say, we want digital assets regulated by FinCEN. We're going to divest the SEC of jurisdiction over them. I don't think that would be the right thing to do. But Congress could come in and say, we've created these regulatory fiefdoms. It's not entirely clear where crypto goes. Maybe it makes sense to not even talk about crypto. Maybe it makes sense to talk about, this kind of crypto and that kind of crypto, and give this kind of crypto over here and that kind of crypto over there. Congress is ultimately the body that could come in and make those decisions. But in the absence of doing that, the regulators themselves are going to have to figure it out. It's like two kids sitting at a table fighting over the last piece of pizza or the last piece of cake. It would be very easy for the parent to come in and say, we're going to split it in half. But if that doesn't happen, instead you're going to have both, it's the exact same situation in the United States.
Sure. And, I've seen Congressman Tom Emmer come out and say XRP is not a security. I know him, Darren Soto, and a few other folks, Warren Davidson, have been trying to push things forward and hoping they make progress on that front and get the other folks on board.
I hope they do. I hope that I would like it. I think it would be wonderful if the House Financial Services Committee and the Senate Banking Committee would sort of both say, this industry has gotten too big and too important for us to not step in and do what we can do here. Hold hearings, take evidence, listen to the lobbyists on both sides, and craft a solution, and then give the regulators a clear green light on what to do. My fear in the absence of that kind of proper functioning of the legislative branch is that, if I were the chairman of the SEC, and let's say I went in and I was going to make crypto a priority, I can guarantee you that pretty soon I'm going to get a request to come testify in front of the HFSC, the House Financial Services Committee, or the Senate Banking Committee, and I'll be roasted by legislators, some who will yell at me for not doing enough to regulate it. A bunch of others will be yelling at me that I have no jurisdiction and how dare I regulate it. I saw this happen when I was at the SEC. It happened over credit rating agencies. And I happened to be at the SEC before there was any formal federal regulation of credit rating agencies. And I had to prepare Chairman Donaldson for these hearings. And sure enough, you go in and you'd have half the members screaming that we're doing too much with credit rating agencies. The other half screaming that we're not doing enough. And the answer was always, folks, it's in your hands. You can pass the rules here. You can create the rules that will then tell us what you want us to do. And sure enough, in 2006, Congress did pass a law on the regulation of credit rating agencies. And so that is really what should happen here, is Congress should do it. But if Congress doesn't do it for whatever reason, I don't think that, given that how big the industry is now, at some point, I think the SEC has to approach it as a regulatory project, as opposed to just playing whack-a-mole with the enforcement, with the enforcement approach.
Sure. Absolutely makes sense. So I want to switch gears a bit for the last topic that I want to touch on, and that is the GameStop short squeeze. I want to get your take on it. Obviously, it's pretty analogous to crypto and DeFi and so forth. What is your take on the whole situation?
Well, I think that's I've been scratching my head over this, like everybody's been scratching their head over it. My first thought, frankly, when this sort of broke into the news a couple of weeks ago, was this is going to be the Eladia Baldwin story. Just something that was kind of weird and funny and diverting, and it seems to be getting to be bigger than that. There's no clear, obvious. It's not a crypto story, right? Yeah. GameStop is, anything but a crypto company, a brick and mortar mall retailer. Where the echoes that I see do involve DeFi and the way, decentralized finance, and the way financial regulators need to start thinking about the new world that we're in. I've read a lot of criticism of the SEC over the past week. I think Senator Warren said something like, you at the SEC, you need to get off your duffs. When I look at what's happening, I don't necessarily see any violations of the securities laws.
Right.
I see there's nothing wrong with shorting. Shorting is an investment technique. There's nothing wrong at all with shorting. In fact, I think shorts have sometimes been our most important sentinels in the marketplace in terms of like pointing out real problems with companies. I think, go back 20 years ago, the shorts were kind of onto Enron before the regulators were. So there's nothing wrong with shorting. So that's the kind of the institutional Wall Street actors in this. And then I look at the folks on Reddit, and I don't see coordinated activity the way that concept is really used in the federal securities laws. I see people expressing their views and other people agreeing with them or not agreeing with them, but then starting to act based on what they're saying in a very decentralized way. And so if the policymakers decide that something like what's going on with GameStop should not happen, then they should start regulating it. And the Senate Banking Committee and the House Financial Services Committee should get together, and they should define what conduct they don't like and tell the SEC to get rid of it. But again, I haven't necessarily seen any conduct that that's so clearly illegal. Now, there may be stuff, could easily be plenty of stuff going on behind the scenes that none of us know yet. Like, there's going to be a lot of people looking into this to see whether there actually is, some sort of hidden coordination or something going on. And that could certainly be the case. I think this will be investigated. But I think that the takeaway for regulators is we live in a very different world from the world we lived in 5 or 10 years ago, let alone in 1933 when the securities laws were written. And it's very easy now for people to I don't want to use the word coordination because that has a meaning in the securities laws, but it's very easy now for large groups of people to, start sort of, taking cues from, a few and start, moving in a particular direction. It was a big joke if flash mobs, the flash mob proposal. It was a big joke a few years ago. Now that's basically the same kind of behavior that you're now seeing here. And the world has changed, and it's really up to Congress and the regulators to look and see how the world has changed and to say, do we need to adapt our regulatory approach? But again, when I read those comments that were attributed to Senator Warren, I just kind of thought it was unfair. I thought it was a bit of a cheap shot at the SEC to say they should get off their duffs. They're off their duffs.
Yeah,
they are off their duffs. And the world changes, and yet they are dealing with the tools that they have, and those tools may need to be updated.
Sure, and I think technology is moving at a rapid pace where these things are popping up because of the internet, the decentralized nature of the internet, and you can't really see them coming sometimes. You have to, react to it, as it happens, but who would have thought that, crowdsourced information could have led to this?
Yeah. And look, regulation and legislation is always going to be a lagging indicator, or, it's always going to follow. It's never going to be able to lead. But that's sort of the point. It's up to the legislature and the regulator to, as best as they can, try to keep up with what's going on in the market and not reactively say that every problem that pops up, we need to figure out a way to solve that, with the constructs that we already know. It's a big lift. It's a really big lift, but I think we could use a lot more legislative policy making here, as well as a lot more, policy making and regulatory focus at the various regulatory agencies.
Sure. Joe, we covered a lot today. I want to wrap it up with some quick rapid fire questions for you. What's your favorite food?
Anything Mediterranean, from Spain all the way to Israel and Lebanon. So
very nice. Favorite musician or band?
I'm too old for your audience. I'd go back to REM and things like that. So
REM, I listened to some REM. Movies? Your favorite movie?
I should probably, say something intelligent like Harold and Maude, but I'm a James Bond fan myself.
Awesome. I can't wait to see the new, I know it got delayed because of COVID, but the new Daniel Craig movie. Favorite book?
My favorite author is a Canadian novelist who died 15 or 20 years ago by the name of Robertson Davies. He wrote probably 15 or so novels. The favorite one of all of them is called What's Bred in the Bone. And I've always said I wish I could find another Robertson Davies. So for those of you who haven't heard of Robertson Davies and you've never read a Robertson Davies book, then there's a treasure waiting you.
Awesome. And when you're not, at the law firm or looking at securities and things like that, what are you doing for fun as far as a hobby?
Eating and drinking, probably.
That sounds good to me. And I know you're down in Miami, so that's awesome. Joe, pleasure chatting with you. Thank you so much for taking the time to join us today.
Thanks, Tony.